Jordan.
Thank you, Mr. Chairman. Mr. McCarthy, just to be clear for the record here, you believe you do not have to show criminal intent in an impeachment proceeding?
You do not have to show criminal intent.
The standard is gross negligence, or breach of public trust, dereliction of duty could be the standard, very appropriate standard.
It certainly takes into account conduct that threatens the constitutional framework but is not criminal and therefore wouldn't require criminal intent.
And Mr. Turley, you would agree with most of that based on your test, but you've talked about recklessness, and you just did that with questions from the last member.
Right, ultimately, you decide as a member of this body as to what warrants impeachment, and certain forms of gross negligence, if you want to use that term,
yep.
in my view, could become impeachable offenses if you're talking about recklessness or deliberate indifference.
Right.
And that's a matter this body has to weigh very carefully.
Okay, Mr. McCarthy, back to you. I'm reading from your written testimony, and you said, it was later in page 14, comparing the articles that were actually filed against President Nixon, you quote this. The articles read, had endeavored to use the Internal Revenue Service to violate the rights of American citizens. They also read that the president was making false or misleading statements and withholding relevant and material evidence or information. Now, let me just give you some. That was from the articles filed against the president against President Nixon. Here's testimony from Mr. Koskinen. He said, if you told me that Tom Kane, Chief Deputy Counsel at the Internal Revenue Service, his Chief Deputy Counsel, said that on February 1st, that he knew on February 1st that there were problems with Lerner's hard drive and they were missing emails. If you tell me he knew on February 1st, I would henceforth say that the IRS knew in February. So, just the facts. Mr. Koskinen's IRS, his Chief Deputy Counsel, is on notice of problems with Lerner's hard drive and server, lost emails, and Mr. Koskinen waits 4 months to tell us. Would that be withholding relevant information, material information from our investigation, do you believe?
Where I come from, and again, not having personally investigated this myself.
Let me frame it this way. You're a former prosecutor. You find out important information. Maybe you didn't find out directly, but one of your other lawyers in your office finds out and is working on the case, and you guys wait 4 months to tell the judge. Would you be in trouble?
No, I can tell you in nearly 20 years as a prosecutor, you screw up a lot of times. When you make a mistake, you are obliged to get to the court and correct the record, not to be called on it to correct it. There may be some rhythm involved in the equation to make sure that you have the facts right when you go to report it to the court, but if it's a matter of great gravity, for example, if I had gotten a court to incarcerate someone without bail on the basis of facts that I find out not to be true, my obligation, no matter how silly it makes me look, is to get to the judge and correct the record.
Correct the record.
Right.
All right, 4 months. It's also interesting in that 4-month time frame, that's actually the time when they destroyed the backup tape. So they knew there were trouble with the main computer that had the emails, and they didn't tell us for 4 months, but in that interval, they also destroyed the backup tapes that would have given us the information, and they did that with 3 preservation orders and 2 subpoenas in place. I also like what you said here from the articles. Endeavored to use the IRS to violate the rights of American citizens. Now, it's interesting they use the word endeavor, because in this case that we're talking about, they didn't endeavor, they did it. 426 groups were targeted systematically and for a sustained period of time by the Internal Revenue Service. I always remind folks, never forget the underlying offense here. The IRS targeted people for their political beliefs. They got caught. Ms. Lerner lied about it when she first went public May 10th, 2013, and said it wasn't us, it was folks in Cincinnati. Then she comes in front of the Oversight Committee, sits right where you're sitting, and takes the Fifth Amendment. When you have that fact pattern, it puts a premium on the documents, the evidence, the material, the emails, and they waited to tell us that they had problems, and then they destroyed the backup tapes that contained the information we needed for our investigation. Ridiculous. Let me ask you this here. Mr. Gerhardt said this should be a last resort. The House has voted to reduce the IRS budget, the Treasury's budget. We have called for the resignation of Mr. Koskinen. We have voted for a special prosecutor to look into this. We voted last week in the Oversight Committee to censure. Last resort, we're there. There is nothing else we can do to reassert, as Mr. Turley said, the rights of the legislative branch, which have been trampled on by this executive branch. So I would just say this, Mr. Chairman. You don't have to show bad intent, criminal intent. Legislative branch rights have been trampled. Mr. Turley pointed out a great fact. Judicial Watch can get more information on the IRS targeting scandal, on Benghazi, on the Clinton email, on anything that's going. They get more information than Congress gets. The underlying offense here was the most egregious thing you can do, going after people's political free speech rights, the right to speak in a political fashion. And John Koskinen, as head of the agency, brought in to clean it up in the President's word and restore confidence in the President's word, allowed 422 backup tapes to be destroyed with 3 preservation orders and 2 subpoenas in place. If that doesn't warrant, all that doesn't warrant us taking this action, I do not know what does. With that, I yield back.
Chair, thank